Hello, everyone, and welcome back to Immigration Talk Show. I'm Nabasa, and I'm going to be your host for today's session. And before we start off and have our guest join us, I have this important disclaimer to keep in mind throughout this whole session. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So I hope you keep that in mind, friends. And we are live right now on YouTube, LinkedIn, Facebook, and you can also just check us out on X and on Instagram as well. Do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. And another best thing is you can join us wherever you're watching. And apart from commenting, whichever platform you're watching us right now, you can also call us and you can do so by dialing the number which you can see in the screen above. The number is 425-436-6335 and the access code is 988-888. So yes, and there's a breaking update. You must have also heard about it. More H-1B workers are reporting NTAs, notices to appear in court. And is this a crackdown or just a confusion at USCIS? Well, we are going to discuss that today. And we're asking, why are NTAs suddenly being issued to H-1B holders? Is this a new crackdown or just a confusion? So to help us, get to know more about this, we have with us none other than attorney Justin Rivera from Wasden Immigration Litigation joining us today after a long time. So really very happy to have you here with us, Justin. Thank you so much for joining us today.
Yeah, thanks for having me. I know it's been a minute. We've been busy over at Wasden. A lot of work coming in. So, but it's always nice to take a break and get to talk to you guys.
Absolutely amazing to have you, and I'm excited for today's session. I'm sure folks out there have a lot of questions and doubts maybe to clarify even. So I'm expecting a lot of you to participate with your questions and keep commenting. That's all I can say. And to start off, Justin, I have questions for you. So if you can tell us what is this notice to appear, the NTA we are talking about today, and why are H-1B holders now, reporting them more often than before? Are you there, Justin? Oh, I think we lost him for a bit, but I do hope that we can have you back. Anyway, Justin, I hope you are here. And if you are, just speak to us. But nevertheless, friends, you can definitely check out Wasden Immigration Litigation. Check them out on LinkedIn as well. And of course, Attorney Justin Rivera. So, yes, this is the news that we have. And do feel free to join us. Whatever questions you have, keep commenting. And check us out, friends. Do not forget to subscribe. You can share this with your friends, family, your folks out there who can benefit most, and ask them also to participate by commenting. And yeah, thank you everyone for joining us today. I can see viewers join us. So I think Justin is back. So Justin, if you did you hear me ask the first question I had for you?
No, I missed all of it. I'm sorry. There's a thunderstorm going on right now. It, of course, conveniently just started about 2 minutes ago. But I could see it on the bottom. What is an NTA and
Yes.
why are H-1B holders now reporting them more often, right? So an NTA is a notice to appear. A notice to appear is the first step typically in a removal proceeding. H-1B holders are not familiar with this process at all because up until the beginning of this year, H-1B holders never had to deal with removal proceedings. Typically, if an individual was on an H-1B and the H-1B, the validity period ended and nothing was filed, the government kind of said, "All right, in good faith, go ahead and just leave. We're not gonna get on your back or put pressure on you to leave the United States." What's happening now is notice to any time an employer withdraws an H-1B petition, if the individual does not have an approved H-1B. Now, the reason why that's suspect is because there is guidance that allows for a grace period to exist where an individual is able to transfer, change status, or depart the United States within 60 days as long as they have a valid I-94. And so what's what's happening now is these individuals thinking that they're doing everything correct in that they file a transfer, the transfer's still pending, they join the new company, which is permissible, and then the old employer withdraws the H-1B. They're shocked because they're receiving NTAs in the mail, basically saying you were in status, the employer withdrew, you no longer have status, and you have to appear in court for a hearing before an IJ to determine whether or not you're subject to removal. Now, it's unprecedented. In the first Trump administration, the strategy that they attempted to employ was to put an NTA in with a denial. So what they would do is, for example, if I was applying for an H-1B extension, they would deny the case, and then in the denial on the last page say there's a notice to appear. And the reason why they ended up not being able to do this is because they couldn't get the information to work. Basically, what they started realizing is they were putting the wrong locations, the wrong times. It was too much for USCIS to handle. And so they did away with the policy and just decided time with this iteration of the Trump administration, their goal is to just issue an NTA anytime someone is not holding status. What's wrong with that is it basically gets rid of the idea of posabag. And posabag is a period of stay authorized by the Attorney General. And that period of stay exists in circumstances where people timely file extensions, changes of status, or in a situation. So that's what's happening now. And NTAs are being issued to H-1B holders on Ls, although I haven't seen it personally. And I have also heard of an H-4 holder being issued an NTA because their B was withdrawn and they had an H-4 pending. And I guess whatever mechanism they're using said, well, if the H-1B is not, and they issued an NTA. And so that's what's happening. And it's creating a lot of confusion because these individuals are people a lot of the time that have been in the country for years on H-1B. They're waiting for the green card backlog. They've got their approved I-140, and they're getting this notice, and they're going, "What the heck is this? I don't understand why I'm even getting this. Shouldn't these be going, to people who entered the country without proper documentation, maybe people who have asylum claims and employment-based immigration?" And so it's led to a lot of confusion and concern.
Well, thank you so much, Justin, for taking that up for us. And, because it's something new, NTA being issued to H-1B. So thank you for giving us an introduction to what we're going to be discussing more today. And I would really like to know, do you think this is a new policy or just stricter enforcement?
Sorry, I didn't catch that question.
I was asking, do you think this is new policy or just stricter enforcement?
I think that it's a circumstance where the government is intentionally operating inefficiently. I think that they're very likely, it's a circumstance where you have DHS failing to communicate in totality, meaning you have USCIS over here, you have ICE over there. They very easily could vet and verify if somebody is actually in POSABAG. What I do is just start issuing these NTAs writ mass. And I think that the reason for it is twofold. I mean, for one,
I think we lost you a bit. We lost you when you said for one, and are you able to hear us, Justin? I think the issue, the connection is a little bad through Justin's side. I think they're having a thunderstorm, friends. Just bear with us. But Justin, if you can hear me, we lost you at. Okay. But anyway, very happy to have you with us, Jay Bhatt. Thank you so much for joining us. We are going to take up your question very, very soon. All you have to do is stay with us and keep commenting if you have more questions. Ask your friends and folks to also join because today we are discussing on this very important topic why are NTAs being issued to H-1B visa holders? And happy to have Attorney Justin Rivera today with us from Wasden Immigration Litigation. Justin, happy to have you back. There was a little disruption, but we lost you at when you were saying for one, what were the reasons you were going to talk to us about?
So for one, an NTA issued to somebody with a pending transfer. How do you combat that? The H-1B transfer is approved, you can terminate the removal status. Well, what happens if the transfer is denied? Then the person has no status, and then it becomes an issue. So what's happening now is that these transfers are actually getting approved. And so as a result of that, I think it further complicates the immigration process. More problems for non-immigrants, because if your case is denied and you have to, you don't have a status to fall back on, and then you do have to deal with the possibility of going into an actual removal proceeding. And so I think that's kind of the underlying intent. And let's backtrack here and say, what is the real justification for it? The real justification for it is that the Trump administration said that they were going to deport more people than any previous administration, right? And so far, they haven't been able to meet the numbers that they want, because the truth is all the people that they want to deport are hard to find. And so because those people are hard to find, because they don't talk to the government, they don't try to make sure that they're in status, they're going to go after the people who do the right thing. And it's all about bolstering their numbers. It has nothing to do with protecting people, keeping the immigration policy clean, none of that. It's all BS, the fraud talk, all of that. It is literally just adhering to this goal, this ideology that they're going to deport the most number of people. And that's why the NTAs are being issued.
Well, thank you so much to be so direct and vocal about that. Thank you so much, Justin. And we do have a lot more questions, but quickly we'll take up Jay since he just joined. And Jay is asking if an H-1B worker does receive an NTA, what realistic options do they have? Can they fight it, leave the US voluntarily, or switch to another status while in proceedings?
So in terms of options in the process, if you have a transfer pending, like I said earlier, you have a transfer pending, your H-1B gets withdrawn, and you get issued an NTA. Once that transfers, you're going to be able to file a motion to terminate with the court. Hopefully, they're going to be able to just say, okay, we have the motion to terminate. Does the government oppose? They shouldn't. They unoppose the motion, and proceedings is terminated. That's great. That's a best case scenario. If you're not in that situation where you have a pending transfer, then you're looking at, did you timely file a change of status before the expiration of your H-1B? If you timely file the change of status, you're in POSA-BAG, period of stay authorized by the Attorney General. Where it gets frustrating is POSA-BAG does not mean that you are blocked from removal, because it's not a status. It's a period of authorized stay. So there's a nuance there in that a period of authorized stay allows you to be in the United States and not accrue unlawful presence, but it's not status. And so because it's not status, if you appear before the court and you're only in a period of authorized stay, it's not sufficient to terminate a removal. Who had done zero removal work prior to the beginning of this year, that's something I had to learn. Because I've told people for years, oh, you filed a change of status to H4, before your H-1B expired and now it's expired, you're fine. The government's not going to do anything. They're not going to care because you're in POSA-BAG. That's changed with the issuance of the NTAs. So you have to timely file a change of status. If you let your status lapse, meaning you did nothing, you didn't change status, you didn't file an extension, you didn't do anything, you just sat on your hands. First off, horrible decision. I don't know why you would do that. But if you receive an NTA, you're going to have to make a decision on what you're going to do there because you can't leave without speaking with the court. If you don't speak with the court and you depart, you could be subject to a bar to reentry. In that circumstance, you can look into voluntary departure, but you need to work with the court to reach that conclusion. You cannot just say, hey, I'm out and leave the United States. That's not sufficient in this process. So those are kind of your options. You could definitely fight it. There are avenues, and I know for a fact that there have been terminated removal proceedings in a good amount of these cases where there have been NTAs issued. So it's more so an issue of just ensuring that you're taking the proper steps to ensure that the proceeding is terminated. And you've got to show up. That's another big thing too. You have to go. You can't not show up because then they're going to issue an order against you. So yeah, I mean, you have options. I would always say consult a removal attorney. I would take an attorney to court with you. I would not go in without representation. But 9 times out of 10, maybe even 10 times out of 10, if you walk in there with an approval notice showing you're holding a status, it's in game. There's nothing the government can do to argue against you.
All right. Thank you so much, Justin, for taking that up. And Jay, thank you so much for participating with your question. If you have any more questions, keep commenting or better even just join us on call. Folks out there, you can join us on call. Dial in this number, which you can see on the screen above. The number is 425-436-6335 and the access code is 988-888. So join us. And Yuri, thank you for joining us as well. We will take up your question, but for now, just stay with us. So, Justin, the next thing, is that, we also saw a lot of questions from users from across different platforms, especially Reddit. One of them was saying H-1B renewal denied. Do I risk on an NTA automatically? And there was another one asking, why are H-1B folks suddenly being treated like they're out of status criminals? And there's another user asking, are NTAs being used more in the Chicago area courts? I keep seeing posts about that. So, anything you have to say to all these questions, confusions, rather?
Yes, I want to say first off, Reddit is a great tool for, coming together and talking, having a platform to share information. It is not an expert hub. So what I mean by that is please be careful with the information that you see on Reddit. I will say this. I like to use Reddit sometimes, even for immigration matters. I like to look and see what trends are and what's going on. The amount of incorrect information I have seen on Reddit is startling. So please be careful with what you look at on Reddit and whether or not it's legitimate. Always talk to a professional first because that professional is actually doing this on a day-to-day basis rather than somebody who used ChatGPT for 3 minutes and is now writing in what was on ChatGPT to score karma points. So all that being said, we'll take these questions kind of one at a time. I think the first person said, if I'm denied, am I going to get an NTA? It's all contingent on your situation. If you get a denial of, let's say, an amendment, and you still have your original H-1B with a validity period, you're still in status, so you're not going to get an NTA. If you get a denial of a transfer and your previous employer withdrew and the transfer is denied and you hold no status, then yes, there's a possibility you're going to get an NTA. If you file an extension and your validity period ends and your case is denied, could you get an NTA? Maybe, because you don't hold the status. By and large, the people that seem to be getting targeted by these NTAs are people whose employers withdraw their H-1Bs when they have moved to another employer, but before the transfer has been approved. The reason why is this. Our understanding of it is that there is basically an AI system being used that shows when someone's H-1B is withdrawn, but does not show if there is another filing. So what that means is the H-1B is withdrawn, and if there is not another approval in the person's profile, then that triggers the NTA. And it all seems like it's being done through an automated system for a reason, because there appears to be no nuance. I don't believe there's any actual officer sitting down and saying, okay, based on this person's immigration history, we're going to issue an NTA. And that's why it's being done. Why are H-1B holders being treated like criminals? Or why are they being targeted in this way? Stephen Miller doesn't like you. There's no other way for me to put it, and I'm not going to sugarcoat it at this point. I'm 8 months into this administration. Let's not lie anymore. Who's in charge of immigration for the Trump administration, regardless of what Donald Trump says about H-1B holders, we like them, regardless about what Elon Musk said about the tech sector needs H-1B employee. Nonsense, okay? They don't like any immigrants, okay? None of them, unless you marry a 70-year-old man. That's the people they're okay with, apparently, because they're in the White House right now. So outside of that, the animus is across the board. It is towards any class of immigration, okay? So that's why. And it gets back to what I talked about at the beginning of this call, at the beginning of what we spoke about. They have deportation numbers that they're not going to hit unless they do these kind of things. And that's why they're doing it. It's purely to try and boost numbers so that they can provide results to their most hardcore supporters. Because when you actually look at polling, a good amount of Americans are pretty against the current landscape of immigration. You know, they've seen it as a bridge too far. They think this is too much enforcement happening. We need to stop and do what he campaigned on, which was going after people that are criminals, et cetera, et cetera. That's not the case, and I don't see it stopping anytime soon, to be blatantly honest with you. So that's why H-1B holders are being treated that way. It's because they see it as an avenue to pump numbers up. Are NTAs being issued more in Chicago? I have no idea. I can't give you a specific. I've seen NTAs issued from people living all over the United States. So I don't know if it's a field office specific thing, but it seems like it's an across the board issue. So that being said, before we get into the next question, there is another thing that I want to point out that's important about these NTAs, aside from the fact that, you know, they create all the issues with people having to go to immigration court and everything. When you go abroad and you apply for a visa, you have to fill out the DS-160, right? The DS-160 asks a question about if you've ever been in removal proceedings before. Anyone that gets an NTA, regardless of the outcome of the NTA, now has to answer that question as yes. The issue that presents is it's probably going to be used as a bar to prevent people from using Dropbox, interview waivers, things of that nature. And so I think there's going to be long-standing ramifications to the issuance of these NTAs. And I think that's part of the point, is to gum up and make the immigration system, which is already not fantastic, more difficult to navigate. Because if you don't say that you were in a removal proceeding, then you have a 6C fraud misrepresentation issue, because they'll claim that you made a material misstatement or intentional false statement.
Well, what can I say? Thank you so much, Justin, for giving us that perspective. In fact, I think after this hiatus, we actually have a new scenario right now, because, I mean, since we last spoke, up until now, there has been a lot of changes and much more coming in, I think. So thank you for that. And Yuri, we will take up your question, but for now, Justin, if you can also tell us, if someone gets laid off, how fast before they risk an NTA?
I mean, so they traditionally have the 60-day grace period to find another employer, but I would say that your employer is going to, when your employer withdraws your H-1B, you need to assume you're going to get an NTA if you're staying in the United States. I think that hopefully employers are going to be more cautious about withdrawing the H-1B and start working with the employee in a circumstance where they're going to be laid off, maybe explaining to them, like, we're going to lay you off, but we're going to give you a little more time than we usually would so that you can try and find a new employer before we withdraw. That's the case for your mom and pop companies. The big guys, the tech companies, the Metas, they don't care. They're going to do what they're supposed to do and withdraw. the talk has basically been 2 weeks. 2 weeks, 3 weeks. If you're still in the United States and you're not on an approved status at H-1B and H-4, a B-2, any of that, then there's a possibility you're going to get an NTA.
Okay, okay. And what about, people who, uh, sorry, I'm so sorry. I was just going to ask, what about those people who are on OPT and they have an OPT expired and H-1B is still pending? What about them?
I don't think, to my knowledge, we've seen NTAs issued there. I haven't personally. If that begins to happen, we'll let you know. The thing about that is it's a little bit more difficult for them to know. They know when cap gap applies and when cap gap doesn't apply. And so I think it's not as streamlined as the way it is for someone that's just on H-1B and has the
Right, Justin. Well, I guess we lost him, but we do have Robert Brave join us. So thank you so much, Robert, for joining us here on YouTube. We will take up your question in a short while. Just stay with us. And do not forget to subscribe. Our handle is at Immigration Talk Show. Check us out on YouTube, LinkedIn, Facebook, X, and on Instagram as well. Justin, we lost you a bit, but if you can just continue, please.
Yeah, sorry guys. I don't know why the service is so bad. It has to be the thunderstorm, but it's incredibly frustrating. I have not yet seen NTAs issued for people that are on OPT with a timely file change of status to H-1B.
All right. So thank you so much for that. And well, I think Yuri, we will take up your question now. Yuri is asking, despite USCIS rules granting H-1B holders a 60-day grace period to find new employment or change their visa status, NTAs are reportedly being issued within just 2 weeks of job loss. Why so?
Yeah, I think it's just the this whole automated process where when the H-1B is withdrawn, they're looking and seeing if the individual has an approval, and if they don't, they're issuing an NTA. It's nonsensical, to be honest, because cases are still getting approved that are filed in the grace period, which means that USCIS is still recognizing and honoring the grace period despite the issuance of these NTAs. So it's a very convoluted mess that I think is being done on purpose, but that's why they're being issued. I mean, like I said a couple of times, the NTAs are being issued because they're hoping they can actually deport a couple people, and that's their end game. It's nonsense. It's never been done. As far as I know, I've been practicing as far back as 2017. It's never been done at any period in which I've been practicing, and it's fundamentally stupid, to be blunt, because we know that immigration courts are already backed up. We know that IJs already complain about their caseloads. So they're adding cases to an already incredibly full caseload. To give you an example, I have someone who their wife got an NTA because their H-4 extension was denied. And at their hearing, their master calendar hearing, which is the first hearing you go to, they went to the hearing and the judge basically said, "Do you need an interpreter?" And the person said, "No, I don't need an interpreter." And the judge goes, "No, I think you need an interpreter. I'm going to move this appointment. I'm going to move this hearing. We'll see you in 6 months." And that's the reason why is the judge is sitting there saying, "I don't have time for this. I have other cases with people where there are serious ramifications and issues to the decision-making process. And you're basically telling me that I've got to deal with this lady who her H-4 extension got denied. A lady who, by the way, is here legally because her I-485 was filed while she was in status, and she has a green card EAD and advanced parole. So it's someone here who is not unlawfully present, but was still issued an NTA. And it's nonsense, but it's nonsense that's being done with a purpose. And the underlying purpose is run up the numbers, make the numbers look like we're deporting more people, that we're charging more people, that we're issuing more NTAs. Let's be completely honest with what we're dealing with this present administration. They got upset by a jobs report last month and went and fired the person who did it. Okay? To think that they're not above trying to manipulate data is nonsense. They said last week they shot out a cable to a bunch of news sites saying that they had revoked 6,000 visas. They said, we've revoked 6,000 visas in the United States. And I thought when I saw that, my goodness, 6,000 visas. More people are getting their visas revoked. They revoked 200 to 300 because for people that they said were anti-Islamic, people who they caught involved in protests or whatever. 200 to 300, right? They took the 200 to 300 and stuck it on top of the people in the SEVIS terminations. So these were not 6,000 new visa cancellations. These were the 5,700 they canceled months ago. All of those kids, by the way, they had to go back and reinstate in SEVIS. You know, they don't talk about that part. But all of those visas, they put 200 or 300 on top and then acted like they canceled 6,000 new visas. So are they not above saying we have initiated removal deportation proceedings against 17,000 people? And really, they've just issued NTAs, but they'll probably pretend that those are all deportations as a way for it to look like they're doing what they're claiming they're going to do. And that's it. That's the long and short of it. That's the whole reason why this is being done.
Well, I think all I can say is immigration is becoming complex day by day. It was already a complex idea. And I think it's always best to consult with an immigration attorney, whatever status you are on, whatever questions and doubts you have, always, get directed by an expert, and that you should do. So an immigration attorney is your go-to. So friends, do visit this link, which you can see on the screen, and check out attorney Justin Rivera from Wasden Immigration Litigation. And Justin, we also have Robert Brave who has joined us, and we should take up his question as well. Is there any legal recourse or protective mechanism for H-1B holders who receive NTAs due to employer non-compliance or delayed withdrawal of Form I-129, 129, despite the employee acting in good faith?
I think it's going to be a case by case type basis. I mean, for one thing, you're saying here that the employer's non-compliance or delayed withdrawal. If the employer's sitting on withdrawing the H-1B, they're actually trying to help you because they're trying to give you more time to find a job. Now, if it's a situation like this, which is what I think it sounds more akin to, if you got a notice of intent to revoke because you were working somewhere without that you weren't authorized to work, the employer is the reason why, or something like that, NOIR, NOID, and the case ends up getting denied, you're in a bad spot because once that denial is issued, you don't have status, you got nothing protecting you. The mechanisms that exist to protect you are basically if you're not paid the wages you're supposed to be getting paid, and that's DOL. And you can use DOL in that circumstance. We've even seen a pretty sizable uptick in people using DOL to transfer employers. And so what I mean by that is a situation where somebody basically doesn't get paid by their employer for a month and they're trying to transfer. They don't have pay stubs. So before you'd be like, well, I'm screwed. I'm going to lose my change of status. No, you report the employer to DOL for the wages, file, and you're usually good to go. USCIS is going to say, well, it's not his fault this guy is not getting paid or this gal's not getting paid. And they're going to adjudicate and then investigate and hopefully get you back wages for that. So that's one circumstance. The other circumstance is, a notice of intent to revoke that's not responded to or ends up getting denied or the employer withdraws. And it's not really the employee's malfeasance that the government doesn't care. The fact of the matter is that you don't have an approval anymore, and it opens you up to the opportunity to have an NTA issued against you.
Thank you, Justin, for taking that up. And Robert, I hope you're happy with the answer you've got. And do not forget to like and subscribe to our channel. Also, share this with your friends and family who can benefit most. And our handle is at Immigration Talk Show. So, Justin, tell us what really happens after receiving an NTA. Do they really have to go to immigration court?
Yeah, you do. If you get a approval in the interim, after the MTA is issued, you can try to file a motion to terminate immigration proceedings. The thing is, it depends on the IJ whether or not they'll accept a written filing in court before physical appearance. And so, what I mean by that is you have to talk to a removal attorney who's in the area that you're in and see what the judge allows. If the judge allows it, my understanding is even if you submit that motion to terminate, if the government opposes the motion, not the judge, but opposing counsel opposes the motion, they're still going to make you show up. So they shouldn't oppose because it doesn't make any sense, because once they show up, proceedings can be terminated. Here's the problem. The government is increasingly becoming just straight up jerks. I don't know another way to put it. I've heard instances where an individual has gotten their case approved through premium processing, and they have the email from the premium unit saying that the case is approved. They said, hey, I don't have the physical approval notice yet, but I have this, and the government knows my case is approved in their system, so can we dismiss? And opposing counsel refused to agree to a dismissal, saying that that approval email didn't constitute an official approval notice. And the immigration judge, who you got to understand, these guys are not used to dealing with this. They are not used to employment-based immigration at all. These people do not come into their courts. The judge is sitting there thinking, well, I mean, I guess it's not an official approval notice, so we got to keep the proceeding open. And they had to keep the proceeding open, which is nonsense because it's a complete waste of resources. They're going to go into court 4 months later and the guy's going to show an approval notice and the case is going to get dismissed. That's docketed. That's a spot that could be going to someone else that has a serious claim that actually needs redress. And instead we're doing this nonsense. But yeah, you have to go unless you can get a motion to terminate and have it filed to the court and the judge is willing to accept it without physical appearance. So I would say the standard is prepare to attend. Go in. I know that it seems disingenuous for me to sit here and say I recommend bringing an attorney because I'm an attorney and I make money off of that. I am not a removal attorney and I'm not going into court with you at any time. I am not saying this because I have removal attorney friends that I want to help get money. I am saying to hire an attorney when you go in for that proceeding, even if you have the paper that's shielding you, because you are not an attorney and you don't know how opposing counsel is going to react or how the judge is going to react. And you need someone there that's advocating for you that's going to get you out of the situation. It's just the easiest thing for you to do. So yes, you need to appear.
All right, Justin, thank you so much for taking that up. And friends, keep commenting wherever you're watching. We're streaming live right now on YouTube, LinkedIn, Facebook, and also check us out on X and on Instagram. So, Justin, I had more questions for you, and if you could tell us, ca- can an employer withdrawal or denial trigger this directly, like getting an NTA?
Yeah, I think if I heard circumstance, it will. In the past, it wasn't something that would happen or be an issue, but unfortunately, with the reality of what it is for now, and that, yeah, if you have a withdrawal and you don't have another benefit category, you're probably
I think we just are you back, Justin?
Yeah, I mean, I don't understand this. It's not even storming that badly. It's really weird to me that I think this might be the most technical difficulties we've had on a call.
Yes, it's been a, but I think we are able to catch up what you're saying. So it could happen that it could be triggered directly, right?
Even yeah, I mean, even now I'm not getting a whole.
Okay.
So I don't know. I don't know if you guys want to. I don't know if you guys want to keep going or you just want to put a button on it. I'll leave it
Sure.
to you guys.
Sure, I think yes, what we can do is maybe we should wrap it up and let's take up Samantha's last question and after that maybe we can wrap it up with the notes you have to say. So Samantha is asking what are the best proactive steps to avoid receiving an NTA after job loss? And would voluntarily departing the US before the grace period ends reduce future immigration risks?
So it's an interesting question. If you depart, let's say you're being told by your employer, "Hey, we're gonna get rid of you on the 30th, at the end of the month. We're sorry. There's no work, no project, or whatever." And you say, "Okay," and then you depart before then. Yeah, you're gonna be shielded. The issue with that becomes now you're outside of the United States. And to get back into the United States, what are you going to need to do? You're going to need to find a new employer that's willing to sponsor your H-1B consular processing. If you got a visa that's still active, you can use that same visa to come back into the US. But if not, then you got to go back through the consulate. And so that means you're applying for a visa at the consulate. And I can tell you, as someone with a lot of experience right now, applying for a visa abroad sucks right now. It is not a fun climate to be going abroad to apply for visas. There has been a significant uptick in denials of visas, refusals under 221G, and now 214B seems to be getting used a lot for the B2 visa and the F1 visa as well. So, yes, that's not applicable necessarily for the H-1B, but it wouldn't shock the conscience if they began trying to utilize the 214B in some way for the H-1B visa. So, yes, for you, I think if you're saying, I want to play the safest immigration game possible, leave before they withdraw, and then you're going to have to deal with it while you're abroad. If you have a visa interview, as long as the company's, legit. So yeah, that is an option. I think the difficulty with a lot of people with utilizing that option is when you're outside the United States.
Right, Justin, thank you so much for taking that up for Samantha. And Samantha, that was a very interesting question. Thank you so much for joining us. Don't forget to like and subscribe to our channel. Our handle is at Immigration Talk Show. And Justin, we really have to cut it short, but it's been good to get an idea about what an NTA is and what are the risks involved and why is it happening. So before we go, if you could actually leave us with an end note, maybe some tips or what we should do if we receive an NTA, you know, it'd be really nice for all of our viewers out there.
Yeah, so I would say if you receive an NTA, the first thing you should do is if you have an attorney, speak with the attorney that, filed your transfer, your change of status, anything like that. Get their insight. What our firm has been doing is, we're working through people's options, and then we're typically saying, okay, we can get this resolved by getting your case approved. Is your transfer pending? Let's upgrade it to premium processing and just get it done. We'll deal with the RFE if we need to get the case approved. Like I said, USCIS still seems to be honoring the grace period in spite of the issuance of these NTAs. So what we're doing is basically working hand in hand with the local removal attorney. We procure the approval, we hand it over to the removal attorney, they go into the court, they get the case removed. And that's been our process that's been successful. It's what I would recommend anyone do. So that would be it. As weird as it is to say at this point, it's the truth. If you get an NTA nowadays and you actually have something filed timely, I wouldn't freak out because you have a recourse. You have a way to get to an end game where this is dismissed without issue. So it's annoying, and time consuming, and it's not right now. It seems this is going to be just another kink in the process that is employment based immigration.
Right. Right. Thank you so much, Justin, for making time for us and the session today. Though we face a lot of technical difficulties, I still had a good time. In fact, after a real long time, we got to have a chat on this very important topic. So thank you so much once again for joining us.
Yeah, it was a pleasure speaking with you. Hopefully, we have better service next time. Maybe I'll schedule our calls around the talk again soon. All right, good speaking with you.
Absolutely. Looking forward already. Have a happy weekend and a happy Friday. Bye bye.
You too.
Thank you. So that was Attorney Justin Rivera, friends, from Wasden Immigration Litigation. Don't forget to check them out. You can check them out on LinkedIn as well. And thank you, each one of you, for joining us here on today's session on Immigration Talk Show. Do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. And do leave your comments if you have more questions on what an NTA is or whatever clarifications you need on NTAs. Feel free to comment on this session wherever you're watching, whether it's on YouTube, LinkedIn, Facebook, and don't forget to also check us out on X and on Instagram. Thank you once again. And yes, this is Nipasa. You can also contact me if you have questions that you want to direct, to the attorneys. Leave me an email. My email is nipa@staffingme.com, and you can also call me or WhatsApp me on my number. My number is 408-335-6444. So this is it. Thank you so much, everyone, for joining us. Have a happy Friday and a happy weekend ahead. Bye for now.